Hello, I'm very excited to inform you that Marina Constas from BBM Attorneys in Bedford View has agreed to make 5 short videos about her book, Demystifying Sectional Titles. Marina's whole approach was to empower estate agents to get the necessary information and the knowledge about sectional titles, and that you can use in your effort in selling units in sectional title schemes. So this is the first one of a series of 5, and the topic that she's going to discuss is the basic terminology and key role players in the sectional title scheme. Very informative. I really enjoyed her video and her seminar, or sessions I should rather say, and as I said, this is the one in a series of 5. Please enjoy. Thank you.
Good morning and welcome to the first episode of Demystifying Sectional Title. Thanks must go to Jan L Jordaan for giving me this opportunity to chat to you about my favorite subject, being sectional title. I really hope that you can gain some valuable insight from what we're going to talk about today in a short 20-minute session. I hope that it's practical and that it gives you good advice as an estate agent selling in the sectional title market. So today what we're going to be speaking about is basic terminology in the field of community scheme life and living, and the key role players. Who have we got to know, who have we got to talk to and be able to market at, and really what are the basic parameters surrounding how we operate in this environment. And I think more and more people are becoming sophisticated. You've got prospective purchasers who are going to be asking you questions as estate agents. And if you're not au fait with the basic terminology, then I think that you're going to be playing off the back foot. So let's try to assist you in that regard today. We're talking about a body corporate. Some people use the term body corporate quite loosely, and many people are not really certain of what it means. So body corporate means the legal body which is made up of all the owners. And when I say the legal body, it's a separate legal entity. And that body corporate is actually capable of suing in its own capacity and being sued. So the body corporate is made up of every single owner. And that means every single registered owner. A developer can also be part of a body corporate if a unit is still in the developer's name. So when we talk about a body corporate, we're talking about the whole complex made up of every owner. Of course, we've got owners, and owners need to be registered at the deeds office. And those owners can hold a title deed, and there's certain conditions relating to that title deed, and they're part of that community scheme. As soon as a sectional title scheme is registered, there's a sectional title scheme number, and each person who's bought into that scheme is registered into that scheme. And there's nobody who can ever say, well, I'm not part of the sectional title thing. I want to opt out. I don't want to be contractually bound by it, and that's it. Everybody has to play the game. And a very wise judge once said, you have the absolute right not to buy into sectional title. The minute that you do, you become bound by all the rules and regulations within that complex. So we've talked about a body corporate. Now we're looking at sections. As estate agents, you need to understand what it means to sell. What are you selling? What is the product that you are providing? And what is the product that you are trying to market at your purchasers? A section is basically the square meterage of the property that the person is residing in, and the section is made up until the median line of the outside. So if you look at the outside wall of a scheme, say this is the wall, there's a median line which cuts 50% vertically down the wall, and the 50% of the wall inside the unit belongs to the owner, and the 50% on the outside is common property. And that is exactly the same for the ceiling and for the floor. So the ceiling if you cut the ceiling in half, the slab in half, the side that comes in, the 50% that comes in on top of your head, let's say, that belongs to the section owner, and above that would be common property. So that's your section. And the section, you'd be able to see the square meterage from a very simple deeds office search. So you need to look at the deeds office and see, right, what is it made up of? Because it sounds quite simple, but actually you need to have your ducks in a row as an estate agent in terms of the sectional plan and where exclusive use area is, and does a patio form part of a section? Does a balcony form part of the section? I mean, you would think that it might, but balconies I've seen registered as well as common property, which basically means that somebody can pop over, one of your neighbors can sit on your common property balcony and also enjoy it. So you need to understand, is it part of it? Has real implications. It has implications as to if a leak arises, where does the leak arise? Is it part of the section or is it part of common property? And that determines the liability for who has to fix very often or maintain something. So your section is pure square meterage and what is registered at the deeds office. When we talk about common property is really interesting because the committee, and we're going to talk about the trustees at a later point, the trustees have to run, control, administer the common property for the benefit of the body corporate. So what is common property? It's on the sectional plan. That's really your first port of call. And when you open that file, which I really suggest that you put together a file with your sectional plan so that you can see exactly what's what, you'll see that where the common property is. A common property is literally things like the corridors of the scheme, the lifts, often the gardens are common property, but don't take that for granted. Check that out because that might be exclusive use area. But common property could be open landscaped areas. The swimming pool would be common property, and the tennis court maybe would be common property. If you've got a very, very large estate where you have lots of roads and parks and things like that, that would be common property. And every owner, when somebody buys into sectional title, they're buying a section and they're buying a portion of an undivided share, they call it in law, of the common property. And what does that really mean? Well, it means that you have a share in the common property, which is for you, but you don't ever own any particular area of the common property. So you can't say, well, I own the stairs of the swimming pool, or I own a portion of the lift. You own an undivided share in everything. And that common property needs to be maintained and kept up by the trustees of the body corporate. And if you want to put any improvements onto that common property, it's not just a case that the trustees can make decisions about that. And in one of our further sessions, I'm going to discuss with you maintenance and whose job is it to do what, because that's important as an estate agent to understand. When we talk about a section and common property, if you say section plus common property, you can just put an equal sign there, and that means unit. So when you talk about a unit in a scheme, you're talking about the section and the common property as well. What if one of your purchasers walking around says to you, okay, it's a beautiful unit, but I want to extend. I want to extend my section. The section, if I buy it because we're looking at expanding our family, and it would be really, really nice to be able to expand and put a few more square meters, and it looks like this is the perfect place that you can extend. Well, there you need to know that it's a big job. Don't be too blasé about telling people they can extend. First of all, they need to submit plans to both the council and the body corporate. The body corporate, being all the owners, would then have the decision by way of a special resolution to decide whether or not you can extend your square meterage. And once you've got that okay from the body corporate, then you also need to see from a council perspective if there's enough bulk in the complex from a municipal point of view to be able to extend. Not only that, you would need to get a land surveyor in to resurvey and to draft plans and to get approval from the Surveyor General for that extension, because then your liability changes. You've got a bigger unit, you're going to have to pay more levy, and you're going to have a more heavily weighted vote if you're extending. So there's so many complexes, I must say, certainly in the provinces that I've dealt with, Gauteng, Western Cape, KwaZulu-Natal, where there've been illegal extensions. And over the years, it's just, been allowed. Oh, well, he did it. The developer said I could extend, so, I just extended. Well, that may have been okay in the past, but certainly going forward, I think the Deeds Office is going to take a really dim view in complexes where there have been illegal extensions. And I know for sure that in certain Deeds Offices, and particularly in the Pietermaritzburg Deeds Office a while ago, they stopped all transfers in a complex because the extensions were irregular and weren't properly put together by the Surveyor General and properly legally passed. So it's important also, it's good advice to trustees, if you're ever chatting to the trustees, to say, look, there should be to here and no further. You should actually say to people, if you want to extend, if you want to do certain things in this complex, change aesthetics, there are really strict rules and regulations. And certainly now is an opportune time, because of all the changes in legislation and the fact that you need a compliance certificate for your rules in a scheme, to put the rules together and to make sure that you enforce those rules. And trustees have really, really got fiduciary duties, which we'll speak about just now as well. So we've spoken about the body corporate, what a section is, what a unit is, what common property is, and now we're going to speak about exclusive use areas. So exclusive use areas are really interesting. I've always in my career spoken about the elusive exclusive use area, because it's difficult to understand. It's really not so simple. I'm going to try and demystify it and simplify. So exclusive use areas there are registered exclusive use areas where an owner actually owns the real right of that exclusive use area. It's reflected in the Deeds Office as a notarial deed of cession that's tied to that property, and that needs to be ceded on with every sale. So you'll be able to find it on a deed search if it's registered. And if I own a registered right of exclusive use area, I can bond that area, which is really valuable. And I can sell that exclusive use area within the scheme. And that can create really good value. So with your registered exclusive use area, it's your first prize right of exclusive use area. And just because your garden, a garden that you see in the scheme, is walled, don't assume that it's that person's exclusive use area. It could be common property, so double check on that. Your other kind of exclusive use area is your rule-created exclusive use area. That doesn't have such strong property rights as your first prize registered exclusive use area. The rule-created area is either created by the developer when the developer starts the development, or it can alternatively be created by the body corporate by way of a special resolution in the conduct rules. So you actually place in your conduct rules a schedule of areas, of exclusive use areas that tie up to a certain section. And that's created in terms of Rule 10.7 of the Sectional Titles Act. The rule-created exclusive use areas can be changed, can be amended again by a special resolution, and they're not as, it's not as sort of stable, and it's not really a real right that you can bond or do anything else with. But it's still valuable, and many complexes that we deal with, especially the new complexes, have ensured that they've created rule-created exclusive use areas rather than registered ones, simply because it's actually cheaper for the developer to do that, because rule-created registered exclusive use areas, you have to pay the conveyancing fees on each area, which can get a little bit difficult if you are developing a scheme of 150 or 1,000 units at a time. Exclusive use areas, we're going to talk also about levies and paying levies. Just be aware, I'm just sowing the seed now, that if they're registered or rule-created exclusive use areas in a complex, it is actually compulsory for the body corporate, for the trustees, to levy a contribution, an additional contribution. So you have to pay for that exclusive use area. And it's not based on square meterage, it's actually based on cost to defray, maintenance costs, water costs, electricity costs, and that type of thing. So it's almost like, there's no real formula. The trustees just decide how much that should be, but just be aware of it as an estate agent and ask about what the exclusive use area contribution is. Then we're going to talk about participation quota. So participation quota is the square meterage of a section divided by the square meterage of all the sections in the scheme. And that really gives you, that you will find on your back of your sectional title plan. It's quite easy to obtain, to see what percentage of an interest I as an owner have in the scheme. And that percentage will determine how much levy I pay and my voting rights in that as well. So now we're going to just quickly go through what it means to be an owner. We've said you need to be a registered owner. These are the key stakeholders in sectional title. Owners have certain rights and responsibilities. We're going to go through that. And also we're looking at tenants in sectional title. Tenants are important, and why now? Because prior to the legislation, tenants never really had any legal relationship with the body corporate. You always dealt with the owner. If the tenant misbehaved, you dealt with the owner. If the tenant had a problem with the body corporate, they went through their owner. Whereas now, with the community scheme ombud service, tenants are included under the dispute resolution formulation. So a tenant can take an owner to, a tenant can take the body corporate to the community scheme ombud and vice versa. So tenants have become an increasingly important player in the whole on the whole stage. Also, we're going to talk about trustees. Trustees are really the most important, and you find that today, when you ask people to put up their hands to be trustees at meetings, it's with a great degree of caution that people decide to do that, because everybody is becoming aware of the increased responsibility and onus on trustees who don't really want to be sued in their personal capacity if they breach their fiduciary duties. But trustees are that little board that are appointed by the body corporate at every annual general meeting, and the Act dictates how many trustees there can be, but there's no cap on how many trustees there can be. But you do have a minimum number of trustees, and the trustees are the people who have the responsibility to deal with the day-to-day operations, management, and administration of that body corporate. And they deal with mainly maintenance. Things like maintenance is within their realm. And of course, they've got to deal with the levies, but often the trustees give that job to the managing agent. Managing agents are the servant of the body corporate, and the trustees and the body corporate really form the master position, not the other way around. So the managing agent needs to comply with what the trustees tell the managing agent to comply with, and the buck stops with the trustees and not the managing agent, because the agent is simply that, just an agent who acts on instructions. So it's good to make friends with the managing agent as estate agents. Please take my hints, because at the end of the day, the managing agent is the one who's going to be able to give you information about the books of account, about levies, about whatever you want, if there's a plan. And the better your relationship is with the managing agent, the more information you'll get. And it's all about that, isn't it? It's about having the information at your fingertips. So that's really just a start. I look forward to chatting to you in further sessions about all these interesting things which I think you need to know about. I think you've got a great and really fantastic job selling in the sectional title field. And if you become really good and really professional and have high degrees of integrity in this field, I think it certainly provides you with a great advantage. So good luck, go out there, do lots of sales, and yeah, I look forward to chatting to you next time.
Oh, thank you, Marina. Yes, that was really, really interesting. I personally enjoyed it. I hope you did as well. Knowledge is power, people. Make use of the knowledge that Marina is sharing with us, and may you be very successful in selling sectional titled units. Remember, number 2 of the series of 5 will follow soon. Thank you. Bye-bye.